Your title is messed up. You need the probate court to assist you in resolving your title issue. Hi, I'm Darren Findling of the Probate Pro, and the intersection between quieting of title, resolving title issues, and probate occur quite often. The reason it occurs quite often is that somebody in the chain of title has now died, and you need the probate estate to be opened and a letter of authority to be issued to resolve the gap in title. Let's break this down. First, with a car, with a vehicle, you have a piece of paper called your title. But with a house or real estate, it is the collection of those deeds that are in a chain recorded at the Register of Deeds that make up and constitute whether you have marketable or clear title. If person A conveys to B and B to C and C to D, and that last person has title, we say that title is marketable and clear. But if person A gives to B, and then there's a gap, and then C gives to D, we say there's a gap in title. Now, what happens if you're trying to resolve this issue and the person you're trying to get to execute a deed has now died? Or the person that held a mortgage, or the person that was the holder of the mortgage has now died and you need a discharge of mortgage. Or maybe it was a land contract and the vendor on the land contract failed to issue a deed to the next person and you need to get a deed from the vendor on that land contract. These are all examples of where probate may be necessary to resolve your issue. Another common example occurs when a person dies and then the family remains in the house for many, many, many years and doesn't realize that they need to go to probate to convey the ownership down through the family. Maybe there was a will and they thought that the will itself solved the problem, but they forgot that probate was necessary to get the property out of the decedent's name into the Blvd or the heirs at law of the probate estate. So those are examples of situations in which you may need to go to probate to help resolve your title-related issue. For the personal representative to have standing, for that person to have standing to sign a deed, a fiduciary deed or a corrective deed, they have to be appointed by the probate court, and valid letters of authority have to be issued granting the authority for that personal representative to convey the real estate. Many letters of authority have restrictions that say you can't convey real estate without a court order. So it's important to look carefully at that letter of authority. When the letter of authority is issued appropriately, then a deed can be used to correct the chain of title. We call this quiet title because you're quieting the title issue. People often confuse this with quit title or quick title, but it's really a term called quiet title that just simply means to resolve a gap in title, to clear up and resolve a title-related issue. Now, not every quiet title action, of course, requires the probate court's involvement. The probate court can be used in particular circumstances where you're trying to get a representative appointed to be able to convey the deed into the chain of title to correct the chain of title. So these types of issues can be resolved both at the circuit court level and maybe at the probate court level. All other non-decedent related corrections would occur at the circuit court level, which has jurisdiction of quiet title actions. I've explained in other videos the timeline and process regarding quieting of title. But here specifically, I'm referring to using the probate court to help resolve a title-related issue. If you've got questions about probate, visit us at theprobatepro.com or call us at 833-PROBATE.